Good on the gate. Remind me where we are.
Okay. All right. Good. Well, let's come back to order here this afternoon for our afternoon session, Planning Commission. We are now down to the rebuttal evidence and cross-examination by the applicant. So, Mr. Pike, do you want to, you have 10 minutes here.
I have no cross-examination that I want to make. There are a few things I want to observe. First of all, again, it's clear that opponents will not be satisfied if we obtain an approval today, but we have taken some fairly extraordinary steps that tap our budget on this to above what we should be spending on some additional plantings and fencing and the like that I think Mr. Urban will be in a position to describe as additional binding elements that I'm prepared to agree to. And again, I recognize that won't make people happy, but it's not required. It goes beyond what we could be compelled to do, but in a spirit of trying to get along with our potential customers and to respond to the Planning Commission's concerns, we're prepared to make some additional changes. Now, having said that, there are a few things I want to underscore, and that is that, of course, we don't write the law, but but everyone here is obligated to follow it. And whether the laws are fair or not, it is still the law. And the case law on these issues is absolutely clear. Lay testimony cannot serve as substantial evidence for a cell tower overturn. And you've heard that from all sides here today. Printed articles off the internet, letters from people who are not present to be cross-examined and the like cannot serve as a basis for a cell tower turndown when faced with expert testimony on the other side. That's the rule in the Sixth Circuit, and I think you've heard that from everybody involved in this from a legal perspective. Now, whether it's right or not, whether it's good policy or not, none of that matters. What matters is that's what the law says. And at the end of the day, the only expert testimony that you have received here today, the only testimony has been from witnesses from the applicant. Based on that issue alone, nothing that we've heard today could serve as a basis for a turn down. Now, I also want to revisit a couple of issues on real estate valuation. First of all, the only expert testimony you have here is from the applicant. Second, if you accepted that argument, let's just say that there were 12 witnesses here on the other side, all experts, all saying that everything the applicants said as lay people was true. Even if that was true, if you use that as a basis for a turn down for this cell tower, then the point is that the same argument would apply to a location anywhere within the search area. And if that's the case, then that means there is no spot that could be utilized because it's a non-unique argument and would constitute a prohibition of service in our book, which is a violation of the Telecommunications Act. That's why, in our view, the state law indicates that we are required to consider that issue, which we did. And we satisfied our statutory and regulatory burden in so doing. Also, at the end of the day, virtually all the arguments we've heard are tied to aesthetics. And the case law on aesthetics, the material I put up on the slide from the Sixth Circuit cases were direct quotes. Aesthetics cannot serve as a basis for turn down when it's based on lay opinion. Now, Mr. Carter and I, lawyers are required to disagree from time to time. That's how we make our living. So I would not entirely agree with part of his summary. Certainly he wouldn't entirely agree with mine, I'm sure, on aesthetics. But I think the ruling goes further. But even based on Mr. Carter's interpretation, you have no expert testimony on that issue. Ultimately, it is our view that a decision on this is mandated. We've worked terribly hard to meet all the requirements of your regulations. And the fact that we are asking no waivers, no variances, and the like is testimony to that. The rules for where this cell tower will be placed are determined by you in your adopted regulations. Those regulations, and Mr. Urban will very capably tell me if I'm wrong, allow, subject to Planning Commission approval, cell towers in any zone. Is that correct, sir?
Yes.
So there's no indication in this that there's one zone that's preferred over another or not, under your own rules. We have a limited area where this facility can be placed. We presented expert testimony to prove that, and the height that it's got to be done at. We looked at all tall structures, even though they were outside of that search area. And we're on all the nearby towers already. We also looked at the other tall structure that's outside of the search area, which technically we shouldn't have to do, but we did, and specifically were able to, and specifically disallowed that because it's not in the right place and it's not nearly tall enough. These facilities are not popular until, of course, somebody needs to use their phone. This is a tall structure. However, as you saw from one of my slides, it is short by cell tower standards. We could have proposed something taller, but we didn't absolutely have to have it, so we didn't, so that it could be unlit. We've worked really hard at trying to present not just a professional case, but one that meets all your requirements, and based on the binding elements that Mr. Urban will be reading shortly, you'll see that we've gone way beyond what is required. Now, we can't do any more than that. That's the limit of how far I can go. But we are prepared to undertake those additional steps that he'll describe. I appreciate your attention today and your consideration of cases that I know are not easy. These are the classic NIMBYs. You heard it over and over again from the opponents. We want a cell tower, we want good cell service, and we're in favor of cell service. We just don't want to look at it. Accepting that proposition, and it in no way minimizes the sincerity and heartfelt nature of that feeling. But if you accept that proposition as an argument, there will be no other cell towers, because that will be the argument against every possible site everywhere. And it's why it doesn't constitute substantial evidence and can't. Thank you very much, Mr. Chairman. I appreciate your attention, and I appreciate the attention of the Commission. I also want to offer an additional word of thanks to the staff for their Herculean efforts instead of lunch today.
Thank you, sir. All right, we're down now to rebuttal evidence and cross-examination by the opposition. The folks that are here for the opposition have also 10 minutes, and so whoever would like to go, or if you have any cross-examination or rebuttal evidence, that would be the time to do it. Yes, ma'am. Ms. Davidson. If you would, just give your name again for the record. You don't have to give the address, but just the name.
My name is Vicki Davidson. Thank you for letting me come back up and have another chance to say something. This gentleman here sounds like we have no rights, and I don't agree with that. We have a lot of rights because this is our neighborhood. We got a certified letter in the mail twice. We have rights. Just because he's an attorney for Verizon, and the gentleman who wants to sell the property to Verizon doesn't mean that he can tell you all how to vote. And I don't think that's fair, because by him saying you have to ignore how we feel, that's pretty much telling you all how you all need to vote. And in my opinion, we do have rights because we live there. My cows run that back property. I love my cows. I want to be organic. And I'm going to see that cell phone tower. You're not going to put up a 185-foot tree to have that cell phone tower. Thank you.
You. Anyone else? Yes, sir, Mr. Hedges.
Yes, sir.
Just give your name again for the record, if you would. Just
Okay, Ronald Hedges.
fine. Go ahead.
I failed to point out something here a few minutes ago. Like, this here's my property here, and you can see a line back through here.
You just push on the screen, touch the screen, and it'll make a mark.
Okay, you can see a line that comes in this area.
Oh, okay.
Okay, that's where every time my yard gets mowed, I mow that. All above my pond here, this here, I don't know who put that in, but that's not trees right there. I mow this area just like this other area with my yard up here. Because my daughter and son-in-law, they bring our 3 grandchildren back there, and they'll pitch a tent and camp overnight and fish during the night. Now that's a pond that I built out of my own expense, and I stocked it. I bought the fish for it out of my own pocket. I didn't ask the state to do it, like a lot of them's done. That's out of my own pocket. Like I say, there's no trees in this area. But what I'd like to ask, the pole, the tower is 79 feet from my property line. And I would like to ask Mr. Pike, how many feet is between the fence right here at the corner in this area and my property line?
It's not much, I know that. Just a second.
Yeah, I agree there.
Our actual lease area runs right up to the property line, I believe. Let me look, see if I'm correct on that. Our lease area runs to almost to the existing fence line. Our actual fence is set back a distance, however, from that lease line, so that the fence is set back anywhere from this distance to that
Would you put that on the
distance.
screen, Mr. Pike? Just,
Sure. Ms. Alvey, if you think there's a better drawing to use, speak up, but I think this is the best one. Okay, if I'm interpreting the drawing correctly, and this is drawing P5 in our revised plans that were distributed to everyone, including council and planning staff, that this is our existing lease line. Here's the existing fence line right here. So our lease line comes to just up to that fence line, like so and like so. Our actual fence line for our compound is set back some distance from that, from here to here, and it narrows from there to there.
Am I looking at 20 feet?
If we try to
The front
scale
corner
it.
there?
What? Which dimension? 24 right here, or where?
Go straight out from the tower.
From here to here.
Yeah, that's 73 minus.
sir, we probably need to get you to, so we can get it on the record if you would.
Okay.
I want to know up at the front corner,
Sure, just saying.
Let the engineer-
22. That's the closest.
Mr. Grigsby's undoubtedly the best person to answer this.
Have you,
so.
were you sworn in earlier, sir?
Yes.
Okay, we need your name and address for the record.
William Grigsby, 1302 Main Street, Shelbyville, Kentucky.
And you're the engineer?
Yes.
Okay. Yes, sir. Go ahead.
Licensed civil and structural. This distance is 49. There's another slide that shows that this distance is 73, so it's 24 feet from the fence to the property line.
Mr. Hedges, does that
It's a
answer your
little
question?
closer up at the top corner because the two do not run parallel, but
Does that answer your question, Mr. Hedges?
Yeah, I figure up the front corner must be about 10 feet, or 6 feet maybe.
Okay.
It's pretty close,
Have any other questions?
pretty close.
Okay.
No, that'll do it right for now.
Okay, thank you.
Now, I would like another question for
Okay.
Mr. Pike. I'm not being smart, but what if a tower was gonna be 79 feet from your property line and the fence approximately 4 to 6 feet?
You know, I might be here today with concerns, like you are. But that doesn't alter the fact that this planning commission develops regulations for the deployment of these facilities. They set the rules. We follow the rules to the absolute letter in connection with it. I would like to think that if I came here with concerns today and I saw the experts that were here to testify to its safety, to the need for it, to the fact that it was so carefully planned out, that there were geotechnical examinations done, there were examinations done by engineers beyond what is required under the statutes by bringing in an additional consulting engineer, then I would leave here reassured. That's what I would like to think the answer would be. And certainly that's part of our goal, is to try to present evidence and information, not only to persuade the commission, but to help reassure people that whether you believe whether you like what we're doing or not, that it is clearly well thought out, where every possible safety measure has been taken concerning it, going not just what is required, but going well beyond that. And one of the reasons we do presentations like this is to try to communicate that in a public setting.
Anything else, Mr. Hedges?
Yeah, could I ask one more question?
You're down to about a minute and a half, so I'd like, if there's anybody else, I want to
Just
give them an
one
opportunity.
more, if it's okay.
Go ahead.
I'd like to know if Mr. Khan's property has been actually surveyed, and not going in looking at a previous map, but a surveyor coming out and actually surveying it to be sure that the property line is right, is what we think is right.
Amy went during the lunch and pulled back in September of 2011, a surveyor submitted a, let's see, what is this titled? Survey plat for the estate of Pauline Kahn, and it is done by and stamped by a professional licensed surveyor.
Okay. Well, I'd just like to add, I hope the commission, remembers that it's right against me, and we bought our place in 1989, and I've done a lot of work to it since, so, I'm not happy about a tower, but it's left in the commission's hands. Thank you.
Thank you. Time has expired on as far as rebuttal and cross-examination. We will have an opportunity for a final statement here in just a moment on both sides. And so now we'll move into the final statement of the opposition. So is there anyone, there's 5 minutes for final statements. Is there anybody on the opposition that would like to have a final statement? Anybody would like to have a final statement? All right, seeing no one here, we'll then move into the final statement of the applicant. Mr. Pike.
I think I made that earlier.
Okay, so you're, all right. With that, the hearing on docket PZ 15015 has been completed, And I would now like to ask Mr. Urban if he would outline the binding elements that were talked about and agreed to here at lunch, and also what is going to be required. I'll ask Mr. Carter if what's being requested of us at that point, and then we'll move into motions and like we normally do. So,
Mr. Chairman, could I approach just one moment with Mr. Urban on something directly relevant to the binding element?
do we need to take a break, or are you? I mean, can you?
I can do it in public.
All right, that's fine.
One that we did not include that I'm authorized to do is that additional row of trees on the opposite side within our compound area.
Okay. All right.
And that's on the side, on the west side of the compound.
Ms. Albee, would you put that drawing back up of the plat, or, you know, the outline of the fences, and so we can kind of know what we're talking about on the binding elements?
My apologies, Mr. Chairman, I just wanted to
Oh, that's
make
fine.
sure
No,
that was
not,
clear.
sure, that's fine. You have the one, the bigger drawing that we just had, yeah, that one.
Is that okay?
Yes. That would
Okay.
probably be more appropriate.
What I'm going to do is, I'm going to first read, and this is in your staff report, but I'm going to go ahead and read it out loud so Planning Commission members know the basis for making a decision. It's in KRS 100.987, and it all has to do with the uniform application, and the first 3 points are about the application itself and what needs to be included, but it goes on, and this again is in your staff report, item number 4. After an applicant's submission of the uniform application to construct a cellular antenna tower, the Planning Commission shall, A, review the uniform application in light of its agreement with the comprehensive plan and locally adopted zoning regulations, B, make its final decision to approve or disapprove the uniform application, and C, advise the applicant in writing of its final decision within 60 days commencing from the date of the uniform application is submitted. And there's more to that, but we don't need to read it. Item number 5, under that same statute, is if the Planning Commission disapproves of the proposed construction, it shall state the reasons for disapproval in its written decision and may make suggestions which, in its opinion, better accomplish the objectives of the comprehensive plan and locally adopted zoning regulations. No permit for construction of cellular or personal communication services antenna shall be issued until the Planning Commission approves the uniform application or the 60-day time period has expired. And there are other things, but I think that's really the basis for making your decision. And John, if anything I need to add to that?
No.
So in light of procedural matter, again, it's whether the uniform application is in compliance with the comprehensive plan and zoning ordinances. If you choose to move forward with approval of, obviously denial, you have to state the reasons why you're denying it. If you choose to move forward with approval, there are 3 binding elements in the staff report, and then 5 additional ones. The ones in the staff report say that the guarantee of removal in case of abandonment shall be irrevocable, and the applicant has agreed they would remove, and they agree to these 3 binding elements. Number 2 is any proposed lighting shall meet FAA regulations, and we've heard there won't be any lighting. And the antenna tower shall be maintained in either galvanized steel finish or painted light gray or light blue in color. Now, the additional binding elements as a result of all the testimony and questioning, again, there are 5. The first one being a 6-foot-tall wood privacy fence will be constructed along the east property line, starting approximately 50 feet from the Kentucky 22 right-of-way for a distance of 375 feet. The second one is 12 10-foot-tall evergreen trees will be planted 25 feet on center and staggered along that east property line, starting at approximate location of the existing barn. And this will depend on the best way of screening the adjoining property owner's view of the tower. The next one is a gate will be placed across the access road located where the privacy fence begins, so approximately 50 feet back from the Kentucky 22 right-of-way where the privacy fence will begin. They will put a gate across their access road. All tree heights begin at the top of the root ball. That's just a confirmation that the height is from the top of the root ball, not somewhere else. And then a second row of trees shall be planted on the west property line, property boundary of the compound. So on the fence line facing to the west or Mr. Hedges' property, the applicant has agreed to plant 2 rows of trees along there for additional screening. And the applicant has agreed to these binding elements, if you so choose to incorporate them in your decision.
Before I state agreement for the record, was it, to refresh my recollection, I think I heard evergreen trees.
Yeah.
I thought we were doing white pines
Those
because
are
you wanted something
evergreens.
taller. That is an okay, cool,
Yeah.
cool.
I'm-
Just want to make
you
sure.
know, I like to put it in a little bit broader terms because sometimes trees get blighted, sometimes they're
perfectly-
not available.
perfectly-
So white pine versus a southern pine, a yellow pine versus whatever, as long as it's an evergreen that's intended to grow taller rather than shorter.
Assuming we receive an approval today, I am authorized to accept all of those binding elements as read.
Okay. Mr. Carter, do you have anything to add as far as what's being requested on, like we normally do on the motion? You know, what we need to consider?
No.
Okay. All right, you, commissioners, you've heard the explanation on the binding elements, what they've agreed to accept. Mr. Pike and his applicant has agreed to accept. As chair, I would like to get a motion on the floor first and duly seconded, and then we will open it up for discussion before we vote. So do we have, the chair will now entertain a motion on docket PZ 15015. Mr. King?
Thank you, Mr. Chairman. Based on the testimony and evidence presented, I find no substantive reasons to note to act in denial of this application. Therefore, I move for its approval based on the testimony and evidence presented with incorporation of the binding elements as referenced.
Mr. Carter, is that an adequate motion?
The applicant's finding of facts if they're interested.
I think it has to be a little more detailed than that, because we're gonna, it has to be a little more detailed than that, because we're gonna have to put this in writing, and if it's appealed, it can go either to the state court or it can be appealed to the federal district court, so we have to have specific
Right, so-
findings, and so, I mean, for your reference, the applicant has posited a recommendation, and you can adopt those findings. If, you can make your motion that, to approve it and adopt the findings set forth in the applicant's recommended order, if you agree with them.
Certainly, I intended to incorporate all submissions made by applicant, writing, testimony, and evidence, along with the support of the expert witnesses and the content presented in the hearing today. That is all in reference with it and incorporated within this motion. That is one part of that discussion. The other part is the opposition's testimony failed to bring anything that appeared to be expert or substantive in terms of the subject matter that is before us for decision-making and upon which a valid denial could be based. We don't have anything in those terms in this evidence to stand on in those terms, and that's what I mean by that. I apologize for leaving it too brief, but that is certainly incorporated by reference into all of that on the leading edge of that discussion.
Is that adequate, Mr. Carter?
Yes.
Okay. Mr. Urban, anything? Did he cover the binding elements adequately?
Well, Mr. Pike brought up a good point about when I said evergreen trees. It really is intended to be a taller growing tree. So let me, if I can, just change evergreen to white pine or similar tree.
Mr. Pike, is that agreeable?
Yes, sir.
That way it's not an arborvitae that grows skinny and doesn't effectively, it's
And that's acceptable for the
white
motion.
pine or similar. Yeah.
All right, well, you have a motion on the floor that has been duly recognized and, by our council and is adequate. So do we have a second? Smith seconds. All right, now that we will have discussion. Any discussion on the motion to approve docket PZ 15015, which is an application filed by Central State Towers LLC and Celico Partnership DBA Verizon Wireless for approval of to construct a 125-foot communication tower on 35.672 acres located at the 2500 block of West Highway 22 in the unincorporated Oldham County city. It is continued from our August 2015 hearing. So I wanted to make sure we get all that covered. So is there any discussion on the motion to approve? Mr. McWilliams.
Chairman, whether anybody cares or not, I want to just talk a minute about how I feel and then what I'm going to do. And they contradict one another. I'd be the first to tell you that if somebody was going to try to put a cell tower in my backyard, that I would be here. And you know, it's knowing a little more about this than most folks, because this is not our first rodeo on these cell towers. But the reason I would be here is for things like binding elements. Because I know that the applicants will always give a little more than they let us, right, Mr. Pike? But we've got to, you know, you don't GET unless you ASK, so that's a real good reason for you to be here. So that's how I feel. But what I'm going to do is I'm going to support Mr. King's motion, and the reason I'm going to support it is the law is the law is the law, and I'm just not going to vote to not uphold the law, Brandon. So, you know how I'm going to vote, be mad at me, but that's okay.
All righty. Any further discussion? I've got several down here. Mr. Horton and Ms. Albertson?
Thank you. Yes, like Mr. McWilliams, this is our only opportunity to get to say something about this, and I understand for sure where you folks are coming from. Many years ago, way before I was ever here and involved in the government, I opposed a major tower that came up, and I did everything that you did and did as much as I could do. They built the tower, and I now see an 1,800-foot tower from my house. I thought I was just going to die when they put it up, and actually I don't notice it anymore, and my property values have increased, as well as several of the homes that I know in the area there that have sold. They have increased over that period of time. So I've learned to live with that, and it's all I can help you with. Thank you, Mr. Chairman.
Ms. Albertson, and then Mr. Douglas.
I just would like to echo what Mr. McWilliams said, which is, it's really tough. I know that we need cell towers. I used to live down in Cardinal Harbor by the river, down low. And when I used my cell phone sometimes to call 911, I got Indiana, which didn't do me a bit of good in my emergency. So I appreciate that we need to have them. But my heart goes out to you folks, and I wish I could find some legal reason to say no, but I find no legal reasons, and I got to do what I got to do. Thank you.
Mr. Douglas?
Mine is just concerning the binding element. And this might be a question for staff and Mr. Carter. Obviously, if the commission approves this today, we're obviously probably giving the authority, and I just don't know what's in our policy and a comprehensive plan for co-location of additional provider services on this particular tower. I mean, I know they come in for permits. I'm assuming that's what occurs, or is just an agreement between the applicant.
Well, it is an agreement between a tower owner and the provider, and the only permits needed, because of course in the state statute we always try to encourage co-location, or any additional electrical requirements need an electrical permit, or if they put a separate building, which they typically don't do, for that little shed. It's usually a 10 by 12 shed or something like that, but that's the only requirement. They do that on top of water tanks, they do that on top of buildings, any place where there's an opportunity to put another provider instead of another antenna tower.
Okay, that's all.
Okay. Any further discussion on the motion to approve the construction of a 185-foot cell tower? All right, I see no other hands going up, so Ms. Fox, would you do the vote? And this is a vote to approve docket PZ 15015.
Miss Albertson?
Yes.
Dr. Arvin?
Yes.
Miss Crosby?
Yes.
Mr. Falvey?
Yes.
Mr. Finney?
Yes.
Mr. Douglas?
Yes.
Mr. Horton?
Yes.
Mr. King?
Yes.
Mr. Klingenfuss?
Yes.
Mr. Mesker?
Yes.
Mr. McWilliams?
Yes, ma'am.
Miss Smith?
Yes.
All right, on docket PZ 15015, the motion to approve has been approved on a vote of 12-0. And with that, let's take about a 10-minute recess to reset for our next docketed item, please.
Incorporated the binding elements by.
Okay.
So, yes.
It's meant to be a picture. You couldn't find a crack. Yeah, well, give me your name and number and I'll write them.
Mike? Yes, sir. We're off.
Got your pin pointed. Come on through, guys.
Right, I'm gonna stay.
Name,
You gonna put them in the van? Are you driving the van? I'm just gonna get them out.